Good morning. Ms. Lippincott, good morning.
Yes, good morning.
Before you get started, on behalf of the appellant, would you like to reserve any time for rebuttal?
Whatever time I have left, maybe 2 minutes.
Okay, so what you're telling me by that is when you reach the point where you are finished, as far as this part of it, that'll be what you reserve for rebuttal.
Yes, sir.
Okay, please proceed.
May it please the court, my name is Marcy Lippincott, here today to represent the city of OB. And getting right to the point, Your Honors, there's really only one issue that you need to decide today, and that is on the city's motion for partial summary judgment. If the city, that was denied below, if the city was indeed entitled to that finding that the 2012 certificate of vesting did not vest the 2001 statutory development agreement, then the final judgment and both partial summary judgments for the appellees are in error and must be reversed, as well as the order denying the city's partial summary judgment motion. And the other issues in our briefs would just be moot. Now, the plaintiffs insist that they have a written contract.
So to understand what you just said, you're saying that's the linchpin of everything. And
Absolutely.
If that goes away, then everything falls with it.
Yes, exactly.
So why do you say that? Why didn't it vest, according to your claim?
I say it did not vest.
Correct. So,
And I say it did not vest because, would you like me to finish that, or I'm sorry?
Yes, ma'am. That seems to be the crescendo of all of this.
Right.
You're saying that's the key to everything. So why did it not vest here?
Right. Because, Your Honor, there's absolutely nothing. Well, first of all, the opposing counsel, the other side, the trial court, all agreed that the statutory development agreement had expired. It had a precise 10-year term, that expired before the certificate of vesting was ever talked about.
Is the certificate of vested rights different from the development agreement?
Yes.
So they're different.
Yes.
So-
Let's
so
go
you
back
wouldn't-
and just clarify
You
this.
would you follow the same statutory procedures if you were getting a certificate of vested rights versus amending the development agreement? I understood part of your argument was this didn't go to a public hearing as would be required by an amendment to a development agreement, but they didn't amend the development agreement. I understand the certificate of vested rights may have acted in that, but they received a certificate of vested rights, which looked to me
Well, they didn't receive anything. Let's
the
clarify
prior
that.
developer did, correct?
Yes.
It runs with the
And
land.
the owner, prior developer and owner.
Does it run with the land?
Yes.
Okay. So when they bought the land, they received the certificate of vested rights if it was valid.
Yes.
Okay, so they would have received one if it was valid.
Yes. But that was not until March of 2016. That's when someone bought the property. You know, we have all these names, Red Apple Lockhart and Summit Construction, or the plaintiffs below. They're only Summit got this $3.5 million judgment. Only Summit. And when all the documents in the case show that the title was in Red Apple at Lockwood. Why is that? I don't know.
Well, and to that, it looks like they were collectivized. The appellees, the plaintiffs below, were collectivized throughout the proceedings. I see plaintiffs used in your client's answer I see plaintiffs used in the pretrial stipulation. So that's a feature that strikes this judge as perhaps being waived. So help me understand why that matters.
Okay, first of all, that wouldn't matter at all if the city was entitled to that motion for summary judgment that I started my argument with.
Which I understand.
Okay.
But what I heard you just saying is you have a conflation of Red Apple and Summit, which was part of the argument in the brief, initial brief. And my question of you, if that's the argument you're also making today, it looks like those two entities were used almost interchangeably below.
They were by the plaintiffs, and you'll see that in the first summary judgment hearing, in their motion, in the order, they just use a simple less to combine it all. But where are the facts? The facts are that all the documents showed title in only one of these entities, and that was Red Apple at Lockwood. It didn't show title in Summit. So, regardless of that S by plaintiffs, they never established that Summit had any contractual rights here. Yeah, they made argument about they were combined, but there weren't any facts. The only allegation of fact they try to use is Mr. Lucas. He was the senior vice president of Summit, and they tried to refer to his affidavit.
Was the ownership between the two groups the same? The actual ownership? I understand the titles of the corporations, but was the ownership the same?
What do you mean by ownership?
The individuals who own the LLC, the individuals who own the corporation, were they the same?
We don't know that. That wasn't part of the record.
Well, what do you do with, and I'm looking at the pretrial stip that says plaintiffs purchased the property to develop a charter?
Well, that's pursuant to the two summary judgment orders that the city lost, John. And there's a case management conference transcript in the record that we refer to. And it wasn't agreed. That was,
Well, isn't that the point of a pretrial stipulation? And maybe I didn't understand. I was a trial judge. I was a trial lawyer. I thought a pretrial stipulation was a stipulation. I thought that's what the parties did. They stipulated on facts. So tell me why this stipulation wouldn't be that.
because the city made it clear at the pretrial conference, the case management transcript, that this was simply the position that the trial court judge had decided pursuant to those two partial summary judgments. The city wasn't making a concession. That's the difference.
Okay. What about then? I've got the answer here. In the city's answer, it was admitted that when the developer applied for and received a certificate of vesting in 2012, the entire project was fully developed and constructed, save plaintiffs, possessive plural, 9.63 acres. So again, it's in the answer, it looks like it's admitted it was
that's that problem with that S, Judge. And, the other side sort of makes fun of that S. But it's got great significance. And it was, as the summary judgment movement, which they were for two successful partial summary judgments, they had an obligation under due process to allege elements and have evidence of the critical elements with particularity. And they based their jointness and their ownership on the, I lost my train of thought, on the concept that they were united. and that they really were together. But where is the evidence on that? There is no particularity of allegation or proof. The only allegation there was is that they became the successors in interest by purchase. But the certificate of vesting, the development agreement, all say this goes with the title, just like you said, Judge Becker. And the only documents that they had reflecting the title was Red Apple at Lockwood.
Yeah, back to the answer, and it happened two places that there was an admission that they collectively owned the property. Isn't that binding on your client?
Again, Your Honor, going back to that, I mean, if that was admitted way back then, why do we go through the two preliminary summary judgment decisions and orders? Why do we go through all that if that was all admitted? I mean,
Maybe to deal with the vesting question.
well, let's look at the
That's a
certificate of
part.
vesting. Let's look at the certificate of vesting. We know we had a statutory development agreement, and we know that the plaintiffs admit that it expired. And we know that the certificate of vesting says nothing about continuing that agreement, modifying that agreement, extending that agreement. Doesn't say anything except in the history, it has one line that just says, in the history of this property, it had a development agreement.
Was the city manager, did she have the authority to enter into that agreement or issue that certificate of vested rights? She had that authority, didn't she?
Well, no one would have the authority except for the city to extend that development agreement.
I'm asking about issuing the certificate of vested rights.
Well, the certificate of vesting, the only way that this charter school project is here is based on their argument on the development agreement. Without the development agreement, the only thing that the certificate of vesting talks about is a commercial office development. Their whole argument is based upon the uniting of these two documents. And the city's position is that the statutory development agreement was never a part of this certificate of vesting.
So you're not saying that the certificate of vesting agreement is invalid, you're just saying it doesn't amend the development agreement. Is that right?
It wasn't, yes, it wasn't in existence. I mean,
Well, it existed, but it had expired. They were seeking to essentially extend the development agreements.
well, you know, there's a controversy about that. Because are you talking about Exhibit M now, or are you talking about simply the wording of the certificate of vesting?
Well, I'm trying to make it pretty simple, which is to say the development agreement allowed for a charter school, right? The original development agreement allowed for a charter school.
Yes,
It then expires and the property owners want to get an extension essentially, as I see, whatever, that may not be the correct legal word. But we want this certificate of vesting to say, hey, we want to retain the right to have this charter school, and that's within the development agreement. Please issue a certificate of vesting.
nobody heard about a charter school in 2012 when this certificate of vesting
Well, no,
was
that's
issued.
not my point. They could have used it for, they wanted to use it for whatever purpose they could with the previous development agreement.
The new owners, yes.
Yeah, right. So, and one of those things they could do was a charter school. They didn't have to say as a condition of getting the certificate of vesting, we want to use this for a charter school, we want a certificate of vesting. All they had to ask was, we want a certificate of vesting to allow us to continue to use the property to development consistent.
But if it didn't vest, if the certificate of vesting did not include the development agreement,
Isn't there language somewhere that the certificate of vesting, according to the city staff, quote, allowed for the development of the property consistent with the development agreement, as if the development agreement was still active?
you know, that's why I asked you if you were speaking of Exhibit M. Because Exhibit M was an internal city memorandum. It was not part of the contract. It was not pled as part of this contract.
Well, let me cut to the chase. What did the certificate of vesting vest?
It vested the CDP, Conceptual Development Plan, and the PDP. What it really vested was the zoning of PUD. And it did that, as the city staff explained, because the problem the landowner had then, at that time, in 2012, was refinancing. And so that's all they were concerned about. They weren't concerned about the development agreement. That's why the certificate of vesting says nothing about the continuation of this development agreement. It says nothing about the revival of this development agreement. That's critical. I mean, it's very simple.
To follow up on Judge Makar's question, the PUD, or planned unit development, it included authority it included a school, correct, in the planned unit development?
Only so far as that was included within the development agreement. If you just look at the certificate of vesting, it said nothing about charter schools. It said nothing about anything. The reason,
Did the PUD say anything about
Yes.
schools?
yes,
It did.
but the reason that we're here is that the reason the city took the action that it did and the denial of the development order is because the development agreement, where all the guts were, wasn't a part of the CD. I'm making that clear?
And let me clarify, the original parcel was over 100 acres, and everything was developed according to the development agreement,
Yes.
except for this last, something less than 10 acres. Right? That's how.
Yes,
So at the time of the certificate of vesting, the only piece of property left to be reviewed was this piece of property we're talking about today.
yes. But the idea of a charter school wasn't even there in 2004. And the continuation of the development agreement, without talking about Exhibit M, it's not in the CD. It's not addressed in the CD. Yes, there was that one line, but look at what was attached to the CD. The CDP and the PDP. But the development agreement was not attached. It was not an exhibit. In addition, Your Honor, even if we leave that principle and just go to simply summary judgment and the basic principles there, the plaintiffs had the opportunity to get a new development agreement. And they applied for that and they were proceeding. And then they all of a sudden yanked that application and did not finish it. And they had two opportunities to save their profits from the alleged construction contract. And whether they did that and all the facts that go into that were not properly decided by summary judgment. For that reason alone, you have to reverse the final judgment and send this back. Now, let's look at Summit, running out of time, Summit's interest again.
Would you like to reserve any of the remaining time?
Maybe I'd just like to make 2 points real quick. Summit never should have been a part of this. It was all based on that affidavit, which I showed in the briefs, had no basis. Yes, the city didn't raise it then, but it raised it at its first opportunity at the motion for rehearing time. In addition, you'll look at all the documents having to do with the second partial judgment, and you'll see that all of it talked about their major client, Summit Red Apple's major client, being Renaissance. Then you go to the trial, where we're supposed to have a trial on the amount of those damages, nothing about Renaissance. They now point to one little line in the report that says something like Red Apple, Renaissance, same client. Well, that was never, there was no testimony about that. There was no findings in the judgment about that. There was nothing. This judgment should be reversed. Thank you.
Thank you, and if you would give her a minute for rebuttal.
Thank you so much. Appreciate it.
May it please the court, Rachel Cruz of Gray Robinson on behalf of Applebee's Summit Construction Management Group, whose proud mission is to build and construct charter schools. And as is the case too often, I think charter schools are met with undue hostility from local governments. And here, dating back to when we first submitted our application, we've had to deal with unreasonable and ever-changing arguments from the city dating back to 2015. But let me be clear. There was absolutely and unequivocally never any dispute, question, argument whatsoever regarding the identity of these individual plaintiffs at the trial below, nor any question regarding the identity of the charter school at issue. Everybody in this case, as Judge Jay pointed out, used the collective term plaintiffs. And that's done for shorthand purposes all the time in litigation. But importantly, before the parties did that, including the court, they would set out the individual interests. So you would see plaintiff, Red Apple and Lockwood owns the property, holds legal title. Plaintiff Summit Management is the applicant and the developer. And only thereafter would you see that collective term plaintiffs. And I don't think it's productive for the city to suggest that's nefarious when in every single one of their pleadings and arguments to the court, they use that same shorthand. But I want to make sure that the court understands how clear this record was and when the city knew the facts that they're now trying to dispute. The city knew that plaintiff Red Apple at Lockwood held legal title. And they knew Plaintiff Summit Construction was the actual applicant and the actual developer. That is plainly set out in the 2015 SDO application. That was pre-suit. It's set out in the city's denial of that SDO application and in countless other documents and memos and evidence. It's set out in our complaint. We identify the interests of each plaintiff. Also in our deposition and affidavit testimony. But perhaps most importantly, from the very beginning of this case, from the first round of discovery, the city had all key documents, all the purchase documents. It had the deed for the property that showed Red Apple at Lockwood held title. It had the actual construction contract that showed Plaintiff Summit held the the charter school contract. From documents, deeds, plaintiff's testimony, it knew that Summit's owner and president, Chip Cordes, was also the owner and sole member of Plaintiff Red Apple at Lockwood. There was a complete identity of interest to Judge Boatwright's question.
Well, counsel, if I can interrupt, I'm
Sure,
sorry.
of course.
We've heard from the city that you win, they lose, based upon the linchpin issue of whether the certificate of vesting included the development agreement. And to me, everything else doesn't matter at this moment, because I want to hear what you have to say about that, because as I see it, the question is the certificate of vesting, what did it vest?
Sure.
What did it properly vest?
Sure.
And did the development agreement, which had expired, is there some prohibition against an expired development agreement being revivified or brought back to life by certificate of vesting?
Sure.
It seems like all that discussion is the critical issue in this case.
Okay. So the lower court correctly found that the vested rights contract was unambiguous and by its plain terms incorporated the terms of the development agreement. And as Judge Jay, or actually I think it was you, Judge McCarr, at first the city tried to argue that it didn't even intend for the development agreement to be incorporated into the vested rights certificate. And when we showed the court and the city the memo that was executed in conjunction,
What's the evidence for the trial judge's conclusion that the certificate of vesting clearly included the development?
Sure, because, as the court found, the city's argument that the vested rights contract didn't incorporate the development agreement made no sense. It was illogical and circular. So the city argued that the vested rights contract vested and incorporated the PUD, the CDP, and the PDP, but it somehow didn't vest or incorporate the developer's agreement. But then the city reasoned that because there was no development agreement, that the CDP and the PDP were not really vested because those approvals have no standards and are completely meaningless without the more specific terms of the development agreement. Makes no sense.
Could you have developed a charter school, built it there, without the incorporation of the development agreement?
Well, the PUD zoning, the commercial zoning did allow for school uses in and of itself, but a CDP and a PDP are inextricably intertwined with a development agreement. You cannot even get a PDP if it's not tied to a previously approved CDP and development agreement, which is what the trial court found. And that's exactly what happened here. But in direct contravention to the explicit terms of the contract, the vested rights contract, the city argued plaintiffs would be subject to the new city code, the new comp plan, and we'd have to literally start from scratch.
Well, and from a governance perspective, having worked in government a little bit in my lifetime, there's always the concern of a city council, county commission, adopting something that binds future commissions down the road. Maybe, and I don't know what's the term of the certificate of vesting. Is it forever?
No, it had a term.
Do you know what that is?
I think it was up shortly, a couple years ago,
Okay.
like 20 years.
So there's a concern, I think, from a process perspective, saying when these certificates of vesting are issued, we have some process in place to make sure that they're legitimate, number one, that there's authority for them, and they're not unreasonably binding future commissions or councils or whatever. See what I'm talking about, gentlemen? Assure me that these procedural safeguards have been met.
Yes, so if we're moving forward from the actual incorporation, because there's, because the vested rights contract itself was clearly tied to the development agreement. It made no sense without it. So that's step one. When it comes to the authority, the problem with the city's argument when it comes to the duration of the development agreement is, one, this was a vested rights certificate, okay? That has its own standards. As this court has set out, Citrus County versus Hall, tons of cases. For a certificate of vested rights, you're talking about equitable estoppel principles, substantive due process principles. It has its own standards and its own authority.
Did the city have to approve this, the vested certificate?
Absolutely not.
Okay, so under the city's code or charter, whatever we're talking about here, a staff member had the ability to approve it.
Oh, yes. So, and that goes to Judge Whitewright's question. And if that was undisputed below, by
I mean,
the
that
way.
may not be good government.
Right, but that's what they have done, absolutely. They've changed it since then.
Do you know where in their ordinances, so
Yes.
the city manager issued this,
Yes,
right?
Your Honor.
So do you know where in
Yeah.
their ordinance that authority was given? I didn't see a lot.
Yes, sir.
I don't know that even the ordinances were in the record, and so they're
Well,
talking
I'll give
things
you
that
one
went back in
better.
2001, correct?
Yes, sir. Yes, but so in 2000, and it was 2.1, and I think that provision wasn't evidence, but to be sure, the vested rights contract itself reads, developer made application for a certificate of vesting to the undersigned as the land use administrator of the city of Oviedo, who serves in that position in accordance with the provisions of section 2.1 of the LDC of the city of Oviedo. So clearly it was the land use administrator that was to make that call.
So the current city councils, and they say that's the most boneheaded decision I've ever seen. That staffer never should have done that, but it's fine.
That's correct. And they changed that in 2016, I believe. They changed it. Now the city council makes vested rights determinations, but at the time it was undisputed. It was the land use
I
administrator.
know public hearings were required for the certificate of vested rights.
That is correct.
They changed that now.
That is correct. That is correct, Your Honor.
They changed that after this case.
That is correct. Well, I don't know if that was the impetus, but yeah, that has been changed. So what the city tries to do is conflate 163 standards into a vested rights determination, but you're not going to find any case where the cities have applied 163 provisions to a vested rights determination. So that's problem number one. But regardless, that doesn't even matter in this case, because when the city executed the development agreement, it specifically chose not to incorporate section 163.3229 or its language regarding duration or extension. Rather, it crafted its own provision on duration. And unlike 163.3229, that did not require any public hearing. So of course, cities, since at least the 68 Constitution, have had the power to enter development agreements. They could do so under Chapter 163, they could do so under their home rule power, or both. Chapter 163 makes that clear. Section .32205 provides that all of the applicable portions of Chapter 163 are in addition to the powers that a city normally has. I cite the Matthews versus City of Maitland case, not binding on this court. It was just a Ninth Circuit case, but it was Jay Coyne, formerly of this court, now on the 6th. It also says, look, you can use Chapter 163. You have that authority. You can use your home rule power to do development agreements. And here the city chose to sort of have a hybrid, which of course it was entitled to do. Because if you look at the development agreement, paragraph 23 said the only portions of Chapter 163 that were going to be applicable were .3235, .3241, and .3266. It specifically did not include 163.3229 relating to the duration and extension of a developer's agreement. So it had its own provision on the extension where it wrote, the period of effectiveness of this agreement shall not exceed 10 years except upon the mutual approval of developer and the city council or their successors and assigns. So they specifically chose not to have the public hearing requirement that was in .3229 in the development agreement. And importantly, the city and the prior developer had already amended this thing one time, again with no public hearings and with just the signature of the city manager, with a very similar provision about amendments. And so while the Chapter 163 provision said you had to have public hearings before you could amend the development agreement, the Section 18 of the development agreement said otherwise. It was just the consent of the city and the developer. So the city chose specifically not to have that requirement, that it can just do it by mutual agreement. And it did it before we came along as well.
Did your clients go out and start construction of this charter school, and then at some point they ran into the buzzsaw where they had to go to the city to get some additional certificate, or, I mean, I'm trying to...
No. So we tried, the way the development process flows, we had gotten, under our position, we had gotten all of our entitlements. The next step is to submit an SDO application. That's your site plan. Here's our site plan. We're going to go start turning dirt. And that's when they said, well, first they processed it for a while. Then when they figured out it was a charter school, they changed their tune and said that we had to go all the way back through the process from the beginning. But there was we hadn't turned dirt yet. That's what we were trying to do.
They withheld issuance of, like, let's say you're going to have instead of a charter school, you're going to have, fill in the blank on the property.
Right.
A Walmart. Well, not with 9 acres to be enough for Walmart. But it was because of the charter school, you're saying, that they changed their tune.
That's our belief.
Well, at the hearing, was it that type of discussion? Meaning
That was not dispositive.
It was 3-2 vote.
Correct.
Against your clients.
Correct.
Was there discussion saying we don't want a charter school, we want something else?
No. And that's not dispositive. I won't get into it. I did cite some of the facts.
It's not irrelevant. It may be an undercurrent in the case.
That's right. That's correct.
But what I'm getting at is what was permissible under the vested rights. And it sounds like...
Oh, certainly there's no disagreement that a school would be a vested use under both the PUD and the development agreement. It was specifically listed as a use.
Okay.
I want to say one more thing about authority, because even for the sake of argument, that Chapter 163 applies to vested rights determinations, it doesn't. And B, that the city made 163.3229 part of the development agreement, which it specifically chose not to do. The city still had the authority to extend the development agreement under emergency Florida legislation. Because when it was granted, this was 2012 financial recession, and the Florida legislature from 2009 to 2012 enacted legislation that said a developer could come in, ask the city for an extension of a developer's agreement, and the city couldn't even say no. It was just an automatic extension. And the vested rights contract itself, it says that, the city there specifically cited and relied on that emergency legislation when it granted the certificate of vested rights. And I read from the CB itself, in accordance with the general principle of time extensions for development agreements and permits approved by the Florida legislature in 2009, 10, 11, and 12, some relief should be granted to the developer. Now, the city again wants to say, well, we said we had the authority under that legislation, but we really didn't. But that's not true. So what they're saying is because we didn't, when we came in and we didn't specifically cite that emergency legislation, that somehow that took away the city's power to use it. But that, I think, misses the point, because even if maybe they could have denied us if our application wasn't specific enough to cite that statute, but certainly I don't think that took away the city's power to use that legislation and deem our request sufficient.
What's the current status of the construction project?
Oh, it's dead. We lost the contract.
Okay, so the damages in this case are in their entirety cover the loss to your clients from the project not moving forward.
That is exactly correct.
So there's no potential for the charter school
It was.
to be there at that site?
That is correct.
Because
The charter only lasts, so the charter comes from Seminole County to Renaissance Charter School, and which the city had that charter all along, so they knew who Renaissance was. But that charter only has so much time and so many extensions, so at some point they walked away.
So and there's no other project on the property now?
No, we sold the property during litigation to mitigate damages. So again, I won't go through because I'm running out of time. I won't go through all the citations, but remember that the city had all of these documents. It had the contract, it had the construction contract, the deed, it had the charter from Seminole County to Renaissance. It had testimony clearly explaining the relationship between the plaintiffs and also between Renaissance, the overall charter school owner, and it's had an affiliated company, Red Apple at Oviedo, not to be confused with plaintiff Red Apple at Lockwood, totally different size of the ledger, nothing in common, no members in common, actually on the opposite sides of a contract. But they had all that, and despite that, and there was not a single argument or issue made by the city in 4 years of litigation, 4 city motions to dismiss, 7 affirmative defenses by the city, 3 fully briefed summary judgment motions and hearings, city's multiple motions for reconsideration of the summary judgment orders, pretrial statement, and an entire valuation trial. And in that entire time, there was not a single question. The city never raised the issue of Summit standing, plaintiff's interest, or the identity of the charter school. They didn't even bother deposing Chip Cordes, who is the president of both companies. They didn't bother deposing or seeking discovery from anyone from the charter school folks, Renaissance Group, or their construction affiliate, Red Apple at Oviedo. They didn't even bother deposing our expert before trial. So I believe that, especially with regard to standing, those issues have been waived. In any event, I don't think the lower court abused its discretion in denying the city's motion for rehearing when it raised completely new factual issues that had never been raised before. And when it comes to standing, we cite the Cowart versus City of West Palm, Florida Supreme Court case, because it's clear that standing is an affirmative defense. It has to be raised at the pleading stage. If it's not, it's waived. And in Cowart, there was a wrongful death case, and late in the game, there was an allegation that the plaintiff wasn't the actual biological father of the child. Thus, he wouldn't be the party entitled to damages. And the Florida Supreme Court said, no, that's not fair. You raised that at a time when the plaintiff didn't have a chance to even prove that he was the biological father. It was a standing issue that was waived if it wasn't brought up. And that's exactly what happened here. The city, after 4 years of litigation, summary judgments, motions for reconsideration, evaluation trial, after the close of all evidence, now they want to try to bring up a standing issue that was never an issue below, and we have no way of even bolstering it now. We have no way to put in evidence from plaintiff, show assignments, anything like that now, and that's not fair.
The settlement proposal was $1.5 million. Was that on behalf of the collective group of?
That is correct, Your Honor, and we served that prior to the second summary judgment even being entered, and that the OJ, the proposal for settlements, is from both plaintiffs, and it says Summit gets 1.5 and Red Apple at Lockwood, the other plaintiff, gets 0. So the city knew whose contract this was. They knew who was seeking the damages, and they also knew it was a joint enterprise. That was never an issue. I think what the city is arguing is backwards, because they're saying we failed to prove standing, but that's not how it works.
Is there a proceeding to get trial attorney's fees in this case?
We filed a motion for entitlement to preserve that issue. We have not bothered to set it for hearing because we didn't want to waste time and money, during an appeal. But that would be something we seek below, based on the proposal, yes. The Bank of New York Mellon versus Barber case, I just wanted to mention that because there was an issue at trial as to whether a bank had standing based on a note's authenticity. And the trial court found lack of standing, even though the borrower had not raised that affirmative defense at all until trial. And the DCA reversed and said, no, you can't do that. It's not fair because, again, the bank had no way to know to prepare for that at trial. You can't spring standing on someone like that. So here it's even worse because they didn't even bring it up during trial. The city didn't raise this until a rehearing motion. And I see that I am out of time, essentially, and so unless you guys have any other questions.
Thank you, Ms. Bruce.
Thank you.
In my very brief time left, please. First, I'd like to make it clear, particularly to Judge McCarr, that when I started at the beginning and said, if you rule in the city's favor regarding our motion for partial summary judgment, the other issues are moot. But if you don't rule in our favor on that, then we have all the other issues to go through. And what I heard from opposing counsel is absolutely nothing on the issue of summary judgment. And that is that there's no question, but these plaintiffs had the opportunity to walk away and sustain no damages. They hadn't bought the property when they found out the city that was insisting that they had to have a development agreement. They hadn't bought the property. They could have walked away. In addition, they could have finished their application to get a new development agreement. They didn't do that. They walked away. Now, all those things certainly should have been properly considered by the court with respect to causation, but they weren't. The city was denied that opportunity because of those partial summary judgments. There should have been no final judgment here. There should have been no partial summary judgment.
Thank you. Thank you both. And this being our last show of the day, we are officially in recess.
Thank you.
All right.